cardinal rules of legal writing. I am sure you have encountered hundreds or thousands of rules about legal writing, but I have distilled them into 5 cardinal rules, which I think uh, worked well for me, and I assume would work well for you too. And within a rule, there are sub rules. So the 5 cardinal rules of legal writing are: number 1, be clear and concise. Second, be literate. Third, be accurate. Fourth, be wary of legalese. And fifth, be polite. So let's go over very briefly, one by one, these cardinal rules of legal writing. Number 1, be clear and concise. So that's the first rule. How do we make our legal writing clear and concise? We use short words and phrases. Again, lawyers, especially those who are still beginning in the practice, are fond of imitating legal phrases or using long legal phrases or words that sound like lawyers. So instead of using those words and phrases, why not use the shorter version of them? So instead of saying accordingly, say so. At the present time, present or now, by means of, by or with, close proximity, near, due to the fact that, ito mga paborito siguro ito ng mga lawyers, due to the fact that, due to or since, during the period, during, for a period of, for, in order that, for, in order to, in the event of, if, interpose no objection, don't object. Instead of saying in the near future, you might want to say shortly or soon. In view of, since, is in consonance with, agree with, or follows, subsequently, after, later, then, said, some, such, the, this, that, under the provision of, under, until such time, until, utilize, is also one of the favorites of lawyers. Utilize, use, with reference to, about, another favorite, this one, with respect to. You might want to say about or on, with the exception of or except for. So in the book, I have provided also more examples of words and phrases that you might want to reconsider. Another way of making our legal writing clear and concise is to keep your sentences short. A third, which unnecessarily lengthens our legal writing, is this what we call throat clearing phrases. Usually they appear at the start of the sentence. It's as if you are clearing your throat before you say something. They introduce the sentence, but they add little or nothing at all to its substance. So what are these throat clearing phrases that we lawyers are fond of using? You have these are not exhaustive examples, but these are some of the most common examples of throat clearing phrases. It is important to note that. So if it's important, then do note already. Maybe recall that. Third, it must be taken into consideration that. It must be pointed out that. It is worth observing that. It is beyond debate that. It bears articulating that. It goes without saying that. It should be noted that. So these are some examples of throat clearing phrases that we can dispense with. If you notice, if you delete these throat clearing phrases, your sentence will still be understandable and will still stand. Second cardinal rule is be literate. To be literate, of course, is to follow grammar rules. Again, my position is that it's okay if you don't strictly follow or observe grammar rules in some informal context. But in a formal context, there must be some convention that must be followed. Like in legal writing, you are submitting a formal document, for example, to the court for the consideration of the court. So you owe it to the court to follow certain convention in grammar. This is not to show off, but to achieve, more importantly, greater clarity in writing. For example, if you were to read the sentence, the Supreme Court affirmed the decision of the regional trial court, which is the court of last resort. Now, for us lawyers, and for those who are familiar with the hierarchy of courts, we know that the court of last resort here is the Supreme Court. So the modifier, or the one being modified here, is the Supreme Court, not the regional trial court. But for the uninitiated, or for someone who doesn't know the hierarchy of courts, for an ordinary reader, this might be confusing. The reader might get the impression that the court of last resort is the regional trial court, and in fact, it's the Supreme Court. So the confusion could have been avoided had the writer been more mindful of the rules on misplaced modifier or entangling modifiers. In this case, it's a misplaced one. So to make it clearer, it should be rewritten. The Supreme Court, which is the court of last resort, affirmed the decision of the regional trial court. So in the second sentence, the reader will understand that the court of last resort here is the Supreme Court, not the regional trial court. Second, use words precisely. To be literate is to use words precisely. We use words because the word that we use conveys the meaning that we intend to get across. Kaya sabi ni George Orwell, the meaning should dictate the choice of words and not the other way around. We don't use the word simply because we feel like using it or because the word is in vogue or because there's no other word that we can use to convey our meaning. It should be, the meaning should dictate the choice of our words. Now, one common, although rare, one common form of using the words imprecisely is this malapropism, the unintentional use of a word in place of a word with a similar sound. For example, dead of sale instead of deed of sale. Elicit a response when the proper term should be elicit a response. Quick claim for quick claim. Collaborating evidence for corroborating evidence. Interpolate the speaker for interpolate the speaker. Now another word that is commonly misused nowadays is the word alibi. Alibi is a term of art in criminal law. It's a particular defense that you are not in the place or in the scene of the crime, and it's impossible for you to. You are in a different place so that it's impossible for you to commit the crime. But the word alibi now is used for the word excuse. So we use the word alibi and excuse interchangeably. So instead of saying what's your excuse, we say what's your alibi, although that's not the proper use of the word alibi. Third cardinal rule, be accurate. And this is best expressed in Canon 10, Rule 10.02 of the Code of Professional Responsibility. A lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language of the argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by repeal or amendment, or assert as a fact that which has not been proved. Fourth cardinal rule, be wary of legalese. Now, legalese is the specialized and technical language of the law, but we must disabuse ourselves from thinking that just because it is legal writing, our writing has to be legalese. Now, how do we do it? First, we must divorce doublets and triplets. Ano itong mga doublets and triplets? Usually, these are found in our contracts, agreements, and other legal forms that have been handed down through generations of lawyers. Ito yung mga cease and desist, force and effect, null and void, kind and character, made and entered into, sell, transfer, and convey. Now, why is this so? Kasi sabi ng ibang mga authors that the using doublets and triplets has a long history, and it traces as far back as the early times where the English need to use to use words that have French in origin, Latin in origin, and Old English. So to be precise, at the risk of being repetitive, they use or they take words coming from different origin. So that's why it results in what we now know as doublets and triplets. Second, leave lawyerisms behind. Lawyerisms are words that give writing a legal smell, but they carry little or no legal substance. What are these lawyerisms that are so common in legal writing? Una, itong know all men by this presence. According to Brian Garner, who is an authority in legal writing, this phrase or lawyerism, as they call it, is a legalistic way of saying heads up. One time, I remember I had a client who asked me to draft a memorandum of agreement for him. When I deleted this phrase, I did not include this phrase, know all men by this presence. The client asked, saan na yung know all men by this presence? And the client insisted to put the phrase back to the MOA because the client feared that it might affect the validity of their stipulations. But after explaining to the client that practically it means heads up, or it's an old way of saying or giving notice to the people that you have entered into an agreement. The client, of course, I prevailed. The client agreed with me in the end not to include no all men by this presence in the MOA. Another one is the word witness. It must be the archaic term for witnesses. And you can also dispense this with, instead of putting witnesses, you might replace it with the words background, and then after background, you include in paragraph form your whereases or under the term recitals. Third, pursuant to can be replaced by the short word under, like pursuant to Republic Act. So instead of saying pursuant to, which is a loyalism, you might want to say under Republic Act number, etc. Said. Lawyers use this as a substitute for the, this, or those. Like when you say said agreement, the said accused, the said decision, instead of using these words, no, the agreement, this decision, or those decisions. And then you have such. It means of that kind. But we lawyers use this for the very one just mentioned. Such stipulation, such agreement, such accused. Finally, the last cardinal rule of legal writing is be polite. Now, sometimes our emotion gets the better of us. We are carried away by the delaying tactics, for example, of our opposing counsel, by the seeming bias of some judges, by the case itself. Instead of being emotionally detached, we find ourselves being emotionally attached to the cases that we handle. And that's normal because we are just human beings, who think, who feel, also who empathize with our clients. But we must remember that we are not just our client's servant. We are first and foremost officers of the court, and we have a sworn duty to the court, and we owe it to the court to assist the court in the administration of justice and to serve the public. So, we have now come to the end of the presentation. In writing the book, I subscribe to the idea of Richard C. Whiting, the author of the popular pamphlet called Plain English for Lawyers. My aim is to advocate or to propagate the idea that good legal writing is plain English. It's not about being legalese. It's not about the lawyerisms. It's not about the long-winded sentences. It's about writing plain English.